This bell got here and Sergeant Ashby showed up, which means the phone call had to have been about 2 hours before then. That's pretty early on in the stop. The stop itself, you saw on the video, because Deputy St. Gelais had it on the whole time. We're talking 2 hours and almost 50 minutes for a headlight and further investigation and a drive up to Yarnell from Congress and testing at the station. We have testimony. Well, again, you're never going to hear testimony, at least to this day and age, that if you're above 10 nanograms, you're impaired, or if you're above 20 nanograms, you're impaired. Science isn't there yet. We don't know. There's too many factors involved in this when we talk about marijuana. I will defer to our own experiences, because you're allowed to use your reason, common sense, and experiences in determining things like this. How many depictions of people under marijuana have you ever seen where they're angry? Dude, that's good stuff. Marijuana is a depressant. When has anger ever been a sign of marijuana use? You get laid back. All the movies, I know Hollywood takes liberties, but every single movie I ever saw where there was marijuana use, we're not talking about angry people. They take it not to be angry. What have they proven to you beyond a reasonable doubt? Proven she was angry. They've proven she has some balance problems, but when it came to problems of timing in her head, not by the side of the road, when it was explained properly to her, she got 29 seconds to 30. That's pretty good. The med-tox was given. It was described as extremely weak. It's a field test. It's not admissible. It's another step. She was arrested down there at the scene. There was no way they were going to let her go later. They'd already made their minds up, the two officers did. And I'm not saying they did anything wrong. They did police work, but police work is a lot of opinion too. Your opinion of how well I did this might differ from my opinion of how well I did it. And it may be more difficult for people my age to do than for people Mr. Nunez's age to do. They are standard tests. Unfortunately, that's the best we have. In this day and age, every police officer tells people to walk the line, turn around, come back, and they get judged on that. And I can look at the same person that Sergeant St. Gelais is looking at and come to a total different opinion. She did that okay. Oh, she's all over the place. See the video? That's open to interpretation. The important parts are the scientific ones. You can't fake HGN. It's either there or it's not. Your eyes bounce involuntarily because of some impairing substance, or they don't. So that one, both St. Gelais and Sergeant Ashby saw no evidence of HGN. St. Gelais saw nothing in her eyes. They weren't watery, they weren't bloodshot. Yet 2 hours later, Sergeant Ashby said they were already watery. Who knows what happened in between there? But at the time of the stop, which is the important part, the time that she was driving, was she impaired to the slightest degree? And did they prove beyond a reasonable doubt that her driving was impaired, she was under the influence of a substance, marijuana, and impaired to the slightest degree? All three of those factors. Yes, she was in a car, she was driving, Yes, the blood test came back with the presence of marijuana. Now, marijuana is also a little different than other drugs because there's an impairing part of marijuana and there's a non-impairing part. In years gone by, up until recently, just the presence of marijuana in your system automatically DUI. Science has progressed to say, well, if you have carbo THC in there, it's a derivative. That's the part of marijuana that stays in your system for almost 30 days, and that's the part that got people arrested years ago when they hadn't smoked in weeks, because they still had that carbo. Now they've narrowed it down. It has to be THC. That's the impairing part of marijuana. And the blood test showed that Becky had 12 nanograms per milliliter. Think about what big a number is that? What is 12 nanograms per milliliter? We don't know. Scientists know. It boggles our brains. The fact that we might be impaired. But she had THC. But and the third factor, driving, THC, and impaired to the slightest degree. I don't believe you saw enough evidence of impairment. Now, I know we have a DRE expert. She even said she had to call afterwards to confirm some things. Kudos to her for admitting that and putting it in her report. There was nothing hidden there, other than the time she called, but she was clear. This is an evolving science. It's always changing. They have to keep up to date. They have to have constant training. Once Ms. Bell had become cooperative, the officers toned down to it. They performed professionally, but they came up with the wrong opinion. Beyond a reasonable doubt, she has to be impaired. Missing the impairment part. Can't find her guilty with just driving with THC in her system. You have to find beyond a reasonable doubt that she was impaired to the slightest degree. And I submit to you that the only true response here, the only true finding, is not guilty. Thank you.
When you're ready, Mr. Menendez.
Thank you, Judge. I'm glad the defense and state can agree on some things. She was driving, and she had the active ingredient of THC in her system. And the reason I keep saying active ingredient is true because there is I think it's carbox, so it's a long term, carbo THC. But that's not what the state tests for. The state tests for the active ingredient, the impairing ingredient. Scientific fact, she had it in both. Defense argues Debbie St. Gelais didn't see any HGM. Well, of course not. You heard from Sergeant Ashby, our drug recognition expert, that marijuana doesn't appear in HGM. You don't have a lack of smooth pursuit, meaning your eyes bounce. The one thing you do get is a lack of convergence. It's the cross-site test. Deputy Radford testified that on the scene, which was 2 hours prior to Sergeant Ashby, on the scene, right after she was driving, her right eye wouldn't converge. That means her right eye couldn't come in all the way. The defendant stated she could cross her eyes. That wasn't an issue for her. But when he administered the test, her eye just couldn't come in. That's an involuntary movement. If you're impaired, that is a sign and symptom that it is affecting you right at that moment. Defense also argues that the walk and turn wasn't that difficult for her. She was using her arms a little bit. No, okay, I'll give some of that. But if you watch the footage, and I implore you guys to watch while you're deliberating, but watch it. She's all over the place. She's like this. It's not just a minor put on an arm because she's cut on a pebble. She's barefooted. It was a full-on, almost falling over. Defense also argues that this is kind of a outlandish or drawn-out investigation. They say, we're here months later, all day later for this trial because of the headlight. Don't let them confuse you. You saw the facts. You see the science. Yes, was that what the initial stop was for? Yes. After they made contact, this was not typical behavior from somebody. She was irate. She was yelling. She was cussing. That's not normal behavior. So then, red flags pop off. They're thinking officer safety. What else is going on? They call a DRE to make sure she's not having a medical issue. What did they find? She had marijuana in her system. You're right, there's not a scientific number where it's 1 nanogram in urine period. You're right, it affects everybody differently. So, I'm asking you to look at the evidence. Look at the totality of the circumstances. Look at the observations that they made during their standard field sobriety test. Look at the drug results. Listen to the defendant's own statements. She smoked before she got her kids. Given all of those facts, given all the testimony, look at the totality of the circumstances, you don't have another option but to find the defendant guilty. Thank you.
Mr. Mayes, Mr. Litter. I just have to clear two things with you guys. I'm going to put it in their hands about deliberations on the schedule for it. If they want us to later, you guys are okay with that? I'm just going to put it in their hands. I'm not going to force them one way or the other. The second is there was a lot of video in this. Say that they don't have access to the exhibit. Say they want to see video. I'm going to ask if this is appropriate way. So say they want to see the video. They can send it to us in writing exactly what they want to see. And then we can all come in, no talking, no discussion at all, but we could come in and play the video, put it and leave. Does that sound acceptable? Make sure that they have access to that exhibit if they want to see it.
That's what we could have. If Mike wants to, we can show him, he can come to us and ask us time period, we can say yes, we can show him the time period of time.
I'd be okay with either way. I just don't want to give them all the deliberation, but if they want to see the exhibit, I think it should be available to us. Oh, there won't be any discussion. There'll be pure silence while we play something and leave. Yeah, but I just want them to be specific about what they want to see, so we're not trying to do research on what it is. I just want them to say what they want. We can give it to them. So we should have Mike do that now. Yes, but they'd have to be specific on what that is, and we'd have to actually assist in the timestamps on that. Okay, I just want to make sure it's available to them. We don't have the resource to just give it to them. And I wouldn't want to give them the whole thing, because not everything was shown. So does that sound good? Okay, thank you. So I'm going to go back. I'm going to give the four-person instruction one more time, as well as the closing instruction on this. So when you go to the jury room, you will choose a four-person. In this case, with what we have, that will be this room. You guys will stay here. We will all leave. We'll place the table. We'll allow you to arrange. You can arrange the room however you would like. So there's nothing with that. But we'll move the tables around a little bit before we go, so you guys aren't moving those around. But you will stay in the room. But that role of when you go into the jury room, stay here. You will elect a four-person, and the role of that four-person is important. But remember that the opinion of the four-person is not more important than that of the other jurors. Everybody's opinion counts equally. The responsibilities of the four-person include make sure everybody is present during all discussions and deliberations. preside over the deliberations and make sure that they are conducted respectfully and that all issues are fully discussed. Those discussions should be open and free so that every juror may participate. All jurors should be allowed to state their views about the case and what they think the verdict should be and why. All members must agree unanimously. Therefore, the foreperson should count the votes to ensure that every juror has voted. If you do reach a verdict, fill out the verdict form and then sign it on behalf of the jury. If the jury reaches a verdict, the foreperson will inform the bailiff, which is Officer Colgrove. When we return to the courtroom, we'll have the signed or unsigned verdict forms, as well as any question forms that may have been used. When we do come back to the courtroom, this is written, so I'm accommodating for the fact that you guys are staying here. When we return to the courtroom, we'll ask the foreperson whether the jury has reached a verdict, and the response will be yes or no. And that foreperson is not expected to read any verdict to the court. That will be done by the clerk or the judge. So I'm going to read the closing instruction now. This case is now submitted to you for your decision. When you stay in this room, you will choose a foreperson. That person will preside over the deliberation. I do suggest that you discuss and set your deliberation schedule. We were scheduled here till 5:30 today for this matter to possibly come back tomorrow at noon. Those decisions are in your hands. If you wish to stay later, you are welcome to do so. If you wish to come back tomorrow, you are welcome to do so if that time is necessary. That'll be something for the jury to inform the bailiff of so that we do have an awareness of that. After you have decided on what you want to do with that, please let the bailiff know. You are to discuss the case and deliberate only when all the jurors are together in the room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I gave you during the trial remains in effect when all of you are not in the room deliberating. After you're setting your schedule, I do suggest that you review the written jury instructions and the verdict forms. I'll go over those with you in just a second. It may be helpful for you to discuss the instructions and verdict forms to make sure you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedures, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the paper that you have there, the notepads, just as we did for the witness questions. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing, and I will answer it as quickly as possible. One of the things that we do have is we do have the exhibits, and we did have the video exhibits today. If there is a part of the video that you would like to review, you are welcome to do so. However, to do that, I would need that submitted to me on the form, asking specifically for which part of the video that you would like to see, so I can go over that with the attorneys. We'll allow the bailiff to come back in and play that for you. But if that does happen, there's no discussing the case during that. It would be a matter of him just playing that, you watching it, and him leaving. So there will be no discussions during that time. Remember that you're not to tell anyone, including me, how you stand, numerically or otherwise, until after you have reached a verdict or have been discharged. All 6 of you must agree on the verdict. You must be unanimous. Once all 6 agree on a verdict, only the foreperson needs to sign the form on the line marked foreperson. You'll be given 2 forms of verdict. The verdict forms read as follows, and there is no significance to the order of the forms that reflect guilty or not guilty. The first is we, the jury, being duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant, Becky Heather Bell, guilty of driving a vehicle while under the influence of a drug and being impaired to the slightest degree in violation of 28-1381A1. That is the first form. The second is we, the jury, being duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant, Becky Heather Bell, not guilty of driving a vehicle while under the influence of a drug and being impaired to the slightest degree in violation of 28-1381A1. So now at this time we are going to select an alternate juror. Seriously. And that is numbers 1 through 7. Juror number 6, Mr. Carroll. So what we're going to ask you to do, sir, is I want you to leave your phone number A good contact number with the clerk up front. If you are needed, you will be called. If you are not needed and the verdict is made, then we will call you and let you know that. So you will be excused at that time. Please remember not to discuss the case with anybody prior to us contacting you. Actually, you can give that to Officer Colgrove. All right, thank you. So we're going to leave the room. We're going to leave it with you guys. We do have the exhibits. We do have the exhibit 6. We also do have the video exhibit if it is needed. Is there any question? Well, if there are any questions regarding how to ask for any of that, please put those in writing and we will address those. Does anybody need? Well, you know what? We'll leave the case of water in here. Oh. I don't have my bill. I don't Okay, so exhibit 6, exhibit 4, 6, 1, 6, 1, 6, 1. Please. Yeah, that'd be fine. Okay, let's pull the. Would you guys like us to move a table over for you to the middle, or would you like to sit where they're at?
Gotta sit over here.
Okay.
We'll sit around the table.
Okay, of course, going to note presence of defendant, defense counsel, counsel for the state, as well as members of the jury. Oops. Has the jury reached a verdict?
Yes, we have.
Okay. Mike, could you gather that for us, please? All right, Ms. Bell, will you please stand? So I'm going to read the verdict in the matter. It says, we, the jury, being duly impaneled and sworn in the above entitled action, upon our oaths do find the defendant, Becky Heather Bell, guilty of driving a vehicle while under the influence of a drug and being impaired to the slightest degree in violation of 2813-81A1. Would we like to pull the jury?
No.
Well, I have to say thank you, everybody, for your service in this matter. It is greatly appreciated. I think it's one of the most important things that we do in our country to give people that due process and that ability to have determinations made by their peers. So I do greatly appreciate your service. You are hereby released from the admonition. Make sure you've checked in or you've signed the sheet so you have your mileage correct on that prior to leaving today. Your service is greatly appreciated. Mike, could you let Mr. Carroll know also?
Thank you all very much for your time.
Thank you.
Oh, it does.
I'm going to leave it up to them. I'm going to ask. All right, thank you, ma'am.
Have a good night.
So the jury has been instructed. Mr. Loader, is it a choice to go to sentencing today, or would we like a little bit of time? And I would give whatever time accommodation that you would like.
Okay.
Now would be great, sir.
I say if my computer allows for it.
He is a county employee.
Yeah. Mike, do you get a print pad ready? He just needs to have the fingerprint deal.
Yeah, we like sentencing in the normal course.
In the what?
In the normal course, like 30 days out.
30? Mr. Nunes, would you like to be present for that?
No, that's not.
Okay, Mr. Letter, can I get a Monday in May? Not the 29th.
Monday in May.
And June 5th at the latest. I know it's a little more than 30 days, but we do have that holiday on the 29th.
June 5th would be better.
We said June 5th.
Yes.
Do we have a time? We can pick any time we want, on the half hour starting at 1.
Monday,
Yeah, just Monday,
and
starting at 1.
starting at 1. And you're getting old.
I guess we all are today.
That's my part of this is MSP. 1 o'clock.
Yeah, so this matter for sentencing on June 5th of 2023 at 1 o'clock p.m. You'll need to appear here that day in person. Ms. Bell, the state's presence is waived for that hearing. Thank you. We'll get this out to you tomorrow, then, Mr. Letter. All the clerks are done for the day. We'll get it out to you guys.
Or you'll get it to me Sunday when you do it yourself.
Those days are over. Hopefully, here's to a good budget meeting tomorrow.
Yeah.
So, like I said, there will be support for the victim's advocate, of course, for the county attorney. So,
Yeah.
all right, thank you.
Thank you.